Welcome to Talking Feds One-on-One, deep dive discussions with national figures about the most fascinating and consequential issues defining our culture and shaping our lives. I'm your host, Harry Littman. Welcome to another Talking Feds One-on-One. The federal government has what's known as the Solicitor General, the person who not only handles all the litigation in the Supreme Court, but oversees what's happening in the Court of Appeals to see what could be funneling up and what are outlying cases, what needs to happen. The Commentariat, I'm happy to say, also has its own shadow, I could say, SG. That would be Steve Vladeck, who has recently moved to Georgetown from Texas and is really the expert on all things Supreme Court and courts of appeals, including in his Substack called One First, after the Supreme Court address, which I subscribe to, and I recommend that you do as well. Anyway, he's with us today to talk about a couple things that are hot in the news. Steve, thanks very much for being here.
Thanks for having me, Harry. Great to see you.
How are you finding D.C., which I hear is a little cold right now relative to Austin, Texas? How's the move been treating you and your wife and your kid?
Good. It's nice to be back. I mean, this is my third stint in D.C., so it's nice to be back home. But, moving, I would never recommend moving across country with little kids. But as those things go, this one went pretty smoothly, so I can't complain.
All right. Hey, there's a few things going on. I wanted to start with recess appointments. We have Trump rattling sabers to bypass the normal Senate advice and consent procedure, especially with some clearly controversial nominees to head Department of Justice and Department of National Intelligence. And I just wanted to address it from a legal standpoint first. So he's got a certain contrivance in mind, or somebody does, that's been floated. I wonder if you could talk about it and give your thoughts about its odds of succeeding.
Sure. I mean, so I think there are two different pathways here. One would be easy, at least constitutionally, and one would be fraught. So the easy pathway is to get the Senate to agree to this and basically convince, you would just need 50 senators, plus assuming, the vice president at that point, J.D. Vance, would break a tiebreaker, to agree to adjourn. And as long as the adjournment is for at least 10 days, the president would be able to fill any vacancies until the end of the next session of the Senate, which would be, January 2027.
And when you say agree, you mean agree with the House, or whom are they agreeing with to adjourn?
Just they're choosing on their own to adjourn, right? So if the Senate adjourns, right, for more than 10 days under the Supreme Court's 2014 decision in Noel Canning, then that's a recess for purposes of the Constitution, and the president is allowed to fill up any vacancies without the Senate's advice and consent, and that appointment lasts until the end of the Senate's next session, i.e. January 2027.
All right, that's easy route number one. Okay, go ahead.
Right. The only hitch is that recess appointees don't get paid.
Yeah.
And so, it's that there would come a point where at least some of the recess appointees, even in this maneuver, might prefer that the Senate actually confirm them so that they can actually draw a salary.
Now, let me ask you, would it be unconstitutional for, say, Elon Musk to write him a check to float them?
Yes, it would be it wouldn't be unconstitutional. It would be unlawful in violation of a statute called the Anti-Deficiency Act, right? Private parties can't fund the federal government.
Okay.
So
that's the easy route.
That's the easy way. But Harry, as you know, that depends upon the acquiescence of 50 senators. And we already have at least a handful of significant Republican senators publicly throwing cold water on this, including current Minority Leader Mitch McConnell, right? So
who said flat out this weekend, there will be no recess appointments. All right. So that's the first way. Now, Trump thinks he's got a way to maybe do it even without, I mean, he's, having achieved such a tailwind from his election, he's now actually going after Republicans in the Senate. He thinks he's got a way to mow them down and do it anyway. Yeah,
maybe. I mean, so there's a provision in the Constitution that we should say has never been used that allows, in cases in which the two chambers of Congress cannot agree as to the time of their adjournment, it authorizes the president on his own to adjourn Congress, much as the king might prorogue Parliament. This has never happened. There is questions about what it would even mean to disagree as to the time of adjournment. it is possible that the Senate could agree to the time of adjournment, but just adjourn for a day. And at that point, they'd be satisfying the clause. So, Trump, or at least people close to Trump, have floated this. I will just say, Noel Canning, the 2014 Supreme Court decision that blesses a pretty broad recess appointments power, doesn't bless this. And it's actually, I think, pretty easy to take the three justices who are still on the court who dissented in Noel Canning, Chief Justice Roberts, Justice Thomas, and Justice Alito, and add somewhere between 3 and 6 more votes for the proposition that the president cannot use the recess appointments clause during an involuntary recess of the Senate, because otherwise the Constitution would empower the president to render the Senate a nullity.
All right, so let's push on this a little. So, by the way, those three, they were in dissent, insisting on a sort of even more purist view of the recess clause. The majority blessed the notion of as long as it's bona fide, that is to say, not coincident with these phony baloney pro forma sessions that they were doing at the time, and the last 10 days it would work. And the indications from the three is even that's a little too loose for them. But let me push a little bit more, or ask you a little bit more. Okay, there needs to be some disagreement. First, you've often been very useful in kind of explaining where things come from in the first place. Any idea what this notion was meant to, why were they thinking of a disagreement between Senate and House about whether a recess had occurred?
So the clause exists because you're supposed to not be able to adjourn without the consent of the other chamber, right? And the concern was that one chamber might hold the other effectively hostage.
I see.
Right? And so the idea was, in a case in which one chamber is trying to never consent to the adjournment of the other, the president can force the issue, right? Basically to keep one chamber from almost trapping the other chamber in town, right?
So he would hold them hostage here. Yeah.
Right. But this harkens back to a very different time when Congress was a part-time concern, when neither the House nor the Senate was in session more than they were out of session. And, one of the problems is that all of this has become completely anachronistic because, these days, not only does Congress not end its formal sessions until moments before it starts its next session,
right,
but, the kinds of recesses the founders were worried about don't take place. You don't have, for example, the outset of the Civil War when President Lincoln had no Congress for 13 weeks. After his inauguration. And so I think the real point here is that a lot of this stuff is anachronistic. And the more that President Trump, once he's in office, is trying to use novel readings of these clauses, the more I think even this Supreme Court is going to be completely unsympathetic.
And we will get to that. And it's interesting because it poses, you could argue, a literalistic reading versus a kind, the sort of sense and purpose of not just this clause, but the advice and consent clause in the first place, which is bypassed when you have a recess. Okay, but let me ask, even under the Trump argument, so it looks as if he would enlist his stronger, loyal buddy and House of Congress, the House of Representatives, and Mike Johnson to say, okay, we have a recess. And the clever idea would be, if the Senate agrees, oh, well, then great, there is one. And if they don't, here comes that new provision. But what if they just say nothing? I mean, if, what forces the Senate to take any view vis-a-vis the House's announcement that there's a recess?
I mean, I think, again, right, what it really boils down to, Harry, is the Senate going to cooperate or is the Senate going to not cooperate?
Right.
Right. And if the Senate cooperates, Trump will get away with it. And if the Senate doesn't cooperate, Trump will not get away with it. I mean, I think it really is almost that simple. Now, the larger question, and this is more politics than law, is the threat of Trump doing all of this, going to push for senators who might not have voted in favor of some of these nominees, right, to vote in favor as a way of sort of diffusing, right, the crisis. And that would be pretty, I think, cowardly in my view, but I don't know that it's beyond the realm of possibility at this point.
I got it. And you can see with some of these controversial nominees, individual senators may feel between a rock and a hard place, don't want to cross Trump. Elon Musk says he'll fund a primary challenge to anyone who does. So they just as soon be, quote unquote, forced A little bit like the second impeachment, right? When they could say, oh, we can't do this, but, for a legalistic reason, they'd almost be forced to not have a hearing, not have tough democratic questions, not have to review background investigations that are probably radioactive. So in that sense, I guess, if that's what they want politically, then Trump wins. If it's not, though, you think most likely Trump loses.
I think that's right.
Can I ask one final question about it, which is Trump tries to cram this home and announces a recess appointment based on this provision. He installs Matt Gaetz in office, and Matt Gaetz undertakes official responsibilities, and then somebody sues, saying, well, the DOJ has done something. Here's that signature by the Attorney General. He doesn't have the power to be there. What happens, if you know, to everything that has occurred during the putatively unconstitutional tenure of Matt Gaetz?
We have a fight over something called the de facto officer doctrine.
Mm-hmm.
So there's a whole body of case law about this exact problem, which is, which actions of the government are void, Harry, and which ones are voidable. And, it's hard to generalize, but the short version is courts tend to leave in place regulatory behavior, but not enforcement behavior.
Which the DOJ does a lot of, yeah.
Right? If it's adjudicatory, courts tend not to apply the de facto officer doctrine, right? If it's just otherwise regulatory, courts tend to do so. So, you could imagine maybe some immigration adjudications that would be a quick foil for challenging, for example, if it's Matt Gaetz, who is recess appointed in one of these, contrivances. But there would be a bit of a mess. I mean, hopefully the litigation would move fairly quickly, so you wouldn't have a huge backlog of this stuff. But there is a surprising amount of case law on when the de facto officer doctrine does and doesn't apply.
So that's part of what's fraught. I remember, with the Consumer Finance Protection Board, similar questions coming up. All right, that leads pretty organically to a really trenchant op-ed that you published last week in the New York Times, guest essay, I should say, called Will the Supreme Court Stand Up to Trump? Can it? Let's just talk about that. People don't remember so well that at least early in the first term, there were several instances in which the court, now, of course, it was a somewhat different court, in fact, foiled some of his more aggressive moves, other times where it gave him wins. But your piece says that, starts from the vantage point that court's in a different spot right now. First, as many observers, I'm among them, see Trump possibly going further, well past where he was in his first term, and now that he's gotten rid of all the non-loyalists, et cetera. And the Supreme Court then in a pretty tough spot, given where it now stands 8 years later. Can you explain?
Yeah, I mean, so I wanted to write this piece, Harry, really to do two things. And these things might seem like they're in some amount of tension with each other. I don't think they are, but I think it takes a minute to talk about why. So the first thing was to remind folks that Trump actually fared pretty poorly in the Supreme Court during his first term, not by all accounts, but compared to what we might have expected even a median Republican president to do, right? The court actually blocked much of his second travel ban, right? The court blocked his effort to put a citizenship question on the census. It blocked his rescission of DACA, right? He lost the 2020 subpoena cases. And, what that suggests is that there will be some cases, and Harry, we won't agree on whether they're the right cases, but there will be some cases where Trump goes too far, at least for 2 or 3 of the 6 Republican appointees. And, that raises, I think, 2 challenges for us, right? The first is, what will those cases be? And the second is, when that happens, right, who will stand up for the court? Like, what will be the source of the court's power to rule against Trump and expect that he will comply with the judgment? And, in his first term, I think it was unthinkable that Trump would defy a Supreme Court ruling. He didn't have the same kind of universal support within the Republican Party that he appears to enjoy today. He didn't have this kind of margin in the Senate at most, right? At one point, there was a 52-48 Republican majority, and that majority included people like John McCain. He had a Democratic House for the last 2 years of his term, right? And so I wanted to write the piece to get folks thinking about why we should be worried about a Trump defying the Supreme Court and why this court would be in less of a position, I think, right, to expect compliance than it would have been as recently as 8 years ago, right? How the court's own behavior over the last, 7, 8 years actually has made its own job harder.
Yeah, let's talk about that. I mean, this has always been the stuff of law school discussions, but it's almost by definition the most extreme constitutional crisis. The court it issues rulings. Famously, certain presidents, dating back to Andrew Jackson, have suggested, well, that's fine, but we don't have to follow it. But that has been, as you say, unthinkable for many years, including, let's say, the civil rights era, when maybe Eisenhower received rulings he wasn't happy about, but he immediately enforced them, and we take that to just go hand in hand with the democratic system, and don't give much thought to what would happen if, literally, like on the ground, by the day and the week, if a president just said, "Screw you, Supreme Court." But this sure seems like the president to potentially do it. And whereas other presidents and maybe the American people have held the Supreme Court in special regard and on a special august plane, that just doesn't seem to be within Trump's mindset. So you set out the very real specter that he's he's got all the party strongly behind him. He's a lame duck, as it were, that he just gives them the finger to a ruling. Is that a bigger challenge for them than it might have been 8 years ago if that happens?
Yeah, I mean, I think this is the part that we don't talk about enough, right? Which is the Supreme Court really does depend upon a reservoir of public credibility to ensure that people follow its judgments, right? And what that means is, the Supreme Court issues judgments, Harry, but what makes those judgments enforceable is political will. It was Eisenhower sending the army into Little Rock, right? It was, Nixon turning over the Watergate tapes as opposed to not turning over the tapes, right? The court's decision didn't itself produce the tapes. Nixon chose to comply with it. So, it's a pretty obvious point, actually, but what it means is, you need a political environment in which presidents are going to face serious political consequences for not following adverse Supreme Court rulings. And frankly, I'm not sure we have that environment right now, because I don't know that if Trump told the court to pound sand, there'd be that many Republicans other than a small cadre of lawyers, right, sort of standing up against him.
Yeah, and then what? It's funny. I mean, so Nixon really is the ultimate example. He it was disgrace and exile and the end of the presidency, but it went without saying. So part of it, I think, just to raise it, Steve, is really valuable, because you're not arguing it would happen, but it had been unthinkable, just completely unthinkable. And that's another way of sort of stating the essential stability of the rule of law in the American democratic system. So if it's no longer unthinkable, we've already experienced a real decline in public opinion and confidence that is itself an important political fact. Yeah.
Well, and just, I mean, I don't think we have to speculate that much. I mean, we have two data points that ought to alarm us. So the first is, J.D. Vance, who on the campaign trail specifically, raised the famous but apocryphal quote by Andrew Jackson. When the Supreme Court rules against Jackson in Worcester versus Georgia, Jackson is claimed to have said, John Marshall has made his decision, let's see him try to enforce it. He didn't say it. But Vance, tried that out, right, on the campaign trail. And then you had this January, when the Supreme Court ruled against Greg Abbott in the razor wire case in Texas and said, hey, Biden administration, you can keep removing razor wire. Chip Roy was on Fox News within a couple hours urging Abbott to defy the Supreme Court. Now, that was dumb because there was nothing in the Supreme Court's ruling Abbott could defy. But just, Harry, the speed with which even the sort of political power structure in the Republican Party turned on this court was, I think, really telling, and why I think we ought to be worried that a court that has done so much to erode its credibility on the left might all of a sudden find that it doesn't have that much support on the right either.
It's such an interesting point. And we as lawyers take the Supreme Court as a special third rail. Okay, he'll thumb his nose at, we've seen, for instance, over the last 8 years, members of Congress and the Trump administration say, oh, Congress, thanks for your holding me in contempt. But guess what? Pound sand, as you've just put it. And it's just been a bedrock assumption, but that couldn't happen with the court. And maybe it couldn't, but maybe it could. And just thinking how it would play out, thinking if Dwight Eisenhower had said, well, Earl Warren has rendered his decision, let Earl Warren enforce it in the Southern Civil Rights era, what it would mean for not just the law, but society. So the article is, will the Supreme Court stand up to Trump? Can it? And it's just food for thought, I guess I would say, as we're coming into a period that, to me at least, and to many, sure looks like there'll be a lot of pressure exerted on the Constitution, even more perhaps than in the first term. All right, because we had you, I wanted to take just a few minutes to go from the, sublime or whatever to the ridiculous, and a really friggin' nuts episode that you found yourself in the middle of, involving, to me anyway, kind of notably thin-skinned and petty behavior by a longtime Court of Appeals judge, Edith Jones, who has taken umbrage at your scholarship specifically, to the extent she sees it as criticizing her and her court. Want to just set it up for us and just tell us about it?
Sure. I mean, to make a long story short, right, this was the National Federalist Society Lawyers Convention. And the idea was that we were going to have a panel to talk about the sort of the state of judicial independence. And the prompt was, a really interesting, if I think provocative speech that Canon Shanmugam, who's a noted Supreme Court advocate, had given at Duke Law School in September, where Canon was quite critical of at least some of the calls for court reform on the ground that they are sort of trampling on judicial independence. And, I disagree with that, but I think it's a conversation we ought to have. So it was Canon, and it was Dan Epps from Wash U, and me, and then Judge Edith Jones from the Fifth Circuit was on the panel, and then Judge Jim Ho from the Fifth Circuit was the moderator. And, Canon gave his spiel, and then Dan gave his spiel, and then I gave my spiel, which sadly no one will ever know. And then all hell broke loose because Judge Jones, instead of talking about judicial independence, right, used her time to basically engage in a sustained attack against me on the specific topic of judge shopping and my efforts, over the last 4 years to catalog how much litigants are taking advantage of quirks in federal venue rules that allow for example, nationwide challenges to federal policies to be steered to individually chosen judges in random corners of Texas. So at one point, Judge Jones pulls out a folder in which she has a bunch of tweets of mine that apparently one of her law clerks had printed out and highlighted, which she claimed was evidence of me personally attacking these judges. Harry, you've seen the video. The tweets are like, this case is assigned to Judge Kaczmarek, a Trump appointee.
I've seen the tweets even back then.
Right.
It's a real scholarly point, and not just scholarly, news point. But anyway, go ahead.
So anyway, I mean, I think things really ran off. But I mean, that was sort of all bizarre and awkward and strange and counterproductive enough. To me, things ran off the rails when she accused me of being directly responsible for death threats against Judge Kaczmarek and his family. That's not an accusation you should make lightly.
Right.
And suffice to say, she did not do anything to substantiate either the existence of those threats or any connection between my nerdy procedural critiques of litigants' behavior and death threats against a judge who has issued some fairly controversial substantive rulings of late. What was wild about it, Harry, was folks who know Judge Jones might not be surprised. What was wild about it was the reaction in the room, right? Judge Ho, who was supposedly moderating the panel, had nothing to say, right? Dan defended me a little, but that was it. None of the folks who rose during the Q&A said anything about the exchange. And at one point I even said, I thought the Federalist Society was committed to the principled and respectful exchange of ideas. And when I said that, there was a smattering of applause from the audience, but there were also boos. And so, you add all those pieces together, Harry, and you get just a really disheartening microcosm of what increasingly feels like what our legal debates look like, right? Which is, people like me raise what I think are good faith substantive concerns about either litigants or judicial behavior. And, judges who typically in this context are Republican appointees respond by attacking us or by criticizing us or, this has happened to me before, right? And so I think the whole episode has a bunch of ominous portents for what legal debates are going to look like, going forward. And I'll just say, this actually just happened this afternoon before we recorded. Senator McConnell gave a speech on the floor of the Senate where he defended Judge Jones and called me, quote, one of the field marshals of the academic project to undermine the judiciary. I find that remarkable. I find that unfortunate. And what's especially amusing to me, Harry, you know me, like in our universe, I'm pretty mild and my criticisms are pretty darn procedural. I get a lot of flack from my left because I tend to assume that judges behave in good faith because I give folks the benefit of the doubt, right? So if even I am too extreme, what does that say about everybody else?
Yeah, I would put it even more. Look, I think of you as very legal and committed to the project of legal analysis and legal inquiry and legal right answers. And to me, I call this, there was a comic value, but I certainly noticed people were completely flummoxed, and you can understand why in a sense. It goes to what we were saying before, which is the kind of a special stature of a judge. Now, what goes with that special stature is the complete inappropriateness of the personal attacks on anyone engaging in debate, even if they were well taken, which they were not, against you. And I see Judge Jones here as doing an even more crass version of the thing that has brought the Supreme Court into disrepute. You're in the Federalist Society and undertaking a fundamentally political attack, and the politics of it is essentially, it's coming from this guy and he's in camp A, and that's all we need to know. And yeah, for that's a bad development in America. It's not a very good development in the Federalist Society, nor would it be in the ACS, but it's a friggin', it's just a ethical behavioral aberration by someone wearing a robe. It's just really the opposite of what you should expect from someone who's there to give, what could anyone now hope for the next time one of the, whatever McConnell called it, one of you and your fellow, or I guess I'm one of them, warriors would be in front of Judge Jones, who has really shown inappropriately and also inaccurately, but inappropriately, even if it weren't, her sort of partisan colors, which I do agree has been she's been out there in that respect since taking the bench like 20 years ago. But it's the sort of thing that judges ought not do. And I'm your friend and I would stand up if it weren't, but it doesn't, I would feel the same if it were. Well, a good example might be Ed Whalen, whom we both know, a very staunch conservative, but who's taken some departure from Trump orthodoxy of late, for, to judges to essentially exploit their power to try to belittle people instead of engaging in their ideas, if they should even be doing that on the bench, is, a problem.
Well said. I agree. And part of why I wrote, when I wrote this morning was pretty long, but I think there's a lot to unpack here because I think it's a sign of a lot of deeper problems that are going to get worse, Harry, before they get better.
Yeah. Look, there's a lot to be said for that. As the Trump, there are going to be some judges, not all of them, but there's the Eileen Cannon problem that came at us slowly, but we eventually had to conclude that people had taken their mission as somewhat the same as we fear Matt Gaetz or Robert Kennedy will take their mission, or Tulsi Gabbard, as being one of loyalty to a person and not to the Constitution. Anyway, so I agree. You seem to have taken it quite well and like water off your back, but it's worth noting just for its darker portents.
Well, and Harry, can I say a word about that? I mean, I wrote about this a bit, right? I mean, so I am, right, a white male tenured law professor at a private law school in a blue jurisdiction, right? I have about as much insulation in my job as anyone this side of an Article 3 judge.
Yeah.
Right? But there are plenty of people who aren't nearly as insulated. There are lawyers who have to practice before the Fifth Circuit. There are professors who don't have tenure yet. There are professors who have tenure at public universities in states where the legislatures might want to go after them. And, you know, my concern is that, like, I think Judge Jones in me chose a particularly hard target. There are soft targets out there. And this is why I was so disappointed that the Federalist Society hasn't made any but the most milquetoast, equivocal response. I mean, right at the beginning of Friday's session, Dean Reuter, who's the general counsel and the senior vice president, made some bland remark about how it's really important to the Federalist Society to get people with divergent views. And we thank people with divergent views, right? Not acknowledging that anything had prompted that statement, not acknowledging that anything had gone wrong in the panel Thursday afternoon. And it's just like, I'm not worried about me, Harry. I'm worried about everybody else. And so my reaction's not like, oh, I'm upset because, you know, Judge Jones was mean to me, right? My reaction is I'm upset because, like, other people might be chilled by this completely unprofessional behavior.
And I'll say other people might be emboldened. That's always the problem with Trump, of the people he in his orbit whom he provokes or encourages, but then can disavow. You and I have colleagues, I'm not among them, but who are looking into like security services and the like. We don't think Edith Jones will come at him with a hatchet, but someone who is part of the same ecosystem that Edith Jones occupies and produces hosannas in.
And judges, Harry, before anybody else, should be front and center in de-escalating the rhetoric, not escalating it.
No kidding. Yeah, right. I mean, you know, they are truly vulnerable and kind of defenseless. Okay, on that note, it was, I got to say, quite an episode. But anyway, thanks a lot for schooling us on both recess appointments and the tricky position the Supreme Court might find itself in. Look forward to talking to you as the, you know, potential challenges to basic constitutional norms and principles play out over the next, I think we're a mere 217 weeks away from the end of the second Trump administration. Good to be with you.
Is that all?
There you go.
Thanks, Harry.
Thank you for tuning in to One on One, a weekly conversation series from Talking Feds. If you like what you've heard, please tell a friend to subscribe to us on Apple Podcasts or wherever they get their podcasts, and please take a moment to rate and review this podcast. You can also subscribe to us on YouTube, where we post full episodes, talking books, and bonus video content. Talking Feds remains one of the very few independent productions out there. So if you like the work we do and are inclined to support the show, joining our Patreon is the best way to do it. Plus, you'll get tons of perks like free access to my LA Times op-eds and the chance to join monthly live Q&A sessions. Thanks for tuning in, and don't worry, as long as you need answers, the Feds will keep talking. Talking Feds One-on-One is produced by Catherine Devine, associate producer Gabriella Glick, sound engineering by Matt McArdle, Rosie Dawn Griffin, Hamza Mahendranathan, David Lieberman, and Emma Maynard are our contributing writers. Production assistance by Akshaj Turbailu and Genesis Magpayo. Our music, as ever, is by the amazing Philip Glass. Talking Feds is a production of Delito LLC. I'm Harry Littman. Talk to you later.